Chair Marcus, fellow board members, thank you very much for this opportunity to comment in person on this extremely important issue. As a preliminary matter, we just want to point out that we represent several of the organizations that have been discussing today at length and in detail about their continued concerns. I'm sorry, which, there we go. Who have been, discussing in detail the substance of their concerns over this. And it's our goal today to relay those towards the, the legal issues and legal claims that we think would be significant with relation to these issues. And so we ask as a kind of preliminary matter that any substantive questions or suggestions that you might want with relation to those be directed to those organizations, since they have a lot more substantive background and knowledge with regards to those issues. All right, over the course of this revision process to the Eastern San Joaquin General Order and the State Board's proposed order, this board has rightly acknowledged that there is significant variation in agricultural practices statewide, and for that reason declined granting precedential status to this order as a whole. What continues to concern the organizations we represent pertain to specific quality control standards and monitoring programs this board has identified as precedential. To start, growers themselves and third-party coalitions are given too much deference in regulating their own water practices, exemplified by three features in particular: the allowance of anonymous identifiers and member IDs in submitting management practice and field-level data, the use of third parties to act as enforcement and monitoring intermediaries between agencies and individual growers, and the exemption of certain growers from nitrogen reporting requirements. Furthermore, this board seeks to make precedential a series of somewhat vague standards and categories which have not been adequately fleshed out in the revisions. For starters, this order seeks to establish a surface water monitoring program which will not have specific features for up to another 18 months and does not adequately address other sources of water toxicity. Enforceable standards are also missing, including a lack of calculation methods for AR ratios and difference parameters, a lack of guidance in developing AR coefficients, and the use of an outlier category, which is something of a relativistic category, in identifying growers that fail to abide by those standards. So given the broad definition of regulation in the California Government Code, these policies fall squarely within that category and are therefore governed by the rulemaking procedures laid out in the California and Federal Administrative Procedures Act. By not specifically indexing this order as a precedent decision, which has been a practice in the past, the APA's rulemaking procedures should hold sway. The fact that other regions of the state have not had adequate notice of the development of these rules, nor an opportunity to comment on their design, renders these rules underground regulations, and they should not be given precedential status without closer adherence to those procedures. Thank you.
Thank you, Rob. This past Friday, we were heartened to learn that the board decided to include Dr. Revital Katz-Nelson's comments in the administrative record. Still, we remain concerned about the board's delay in making this decision and about the board's general process for excluding comments from the administrative record. The 14th Amendment and the California Constitution provide that no person shall be deprived of life, liberty, or property without due process of law. And it is the fundamental requirement of due process that a person have the opportunity to be heard in a meaningful time and in a meaningful manner. So in this case, the public has the right to comment on an order that will affect the health of their environment and by extension, their own health and well-being. On December 22nd of last year, Dr. Katz-Nelson commented on the state's water quality and on the order's surface water monitoring scheme. She used the most current scientific information and identified issues that had not been addressed in other parts of the record. Until close of business this past Friday, the board stated that they would exclude her letters from the record because they qualified as evidence rather than as comments. The board provided no other justification except that they plan to convene an expert panel to consider similar issues after the adoption of this order. So while revising a semi-permanent order with statewide precedent, the board chose to rely on data from 2013 and 14 rather than consider Dr. Katz-Nelson's comments. And now, just a few days later, the board is coming to a conclusion about adopting this order, and we are concerned that the board has not adequately considered Dr. Katz-Nelson's comments, and that they did not give her an opportunity to be heard as required by due process principles. The State Board has also imposed restrictions on the public's ability to shape this order by limiting the administrative record. Footnote 17 on page 10 states that the order does not address, quote, new issues raised by several interested persons, unquote. We appreciate that this morning the board provided some clarity as to what those issues are. However, this footnote still does not specify exactly the extent of those issues or who raised them, and it provides no guidance about what the public may continue to comment on. By the logic of the footnote, the board only addresses issues raised in original petitions to regional board orders. And the fundamental problem with that in this situation is that the board took this order up on its own motion and not on a petition. As such, we believe that the board should address all issues raised and that Section 2052 no longer applies. Furthermore, limiting comments to issues within petitions imposes an impossible burden on the public. Petitioners must have anticipated revisions to the order in 2014, which was 3 years before these revisions were actually made. And at the time of the petitions, the board had not yet decided which issues or which aspects of the order would be precedential. Those decisions raised new issues that petitioners could not possibly have addressed in 2014. And finally, the board only accepts comments on red lines from their most recent revisions, which requires the public to track in detail changes between orders. This complicated process undermines the fundamental purpose of notice and comment and the long-standing principles of procedural due process, which require the board to meaningfully involve the public in protecting water quality statewide. Two other issues of concern involve the order's reliance on third parties and on a proposed expert panel. On page 21 of the latest order, the board explains that third parties are necessary because they provide technical capacity and staff that regional boards lack. Regional boards should not issue permits that they lack the staff to enforce, and the state board should not condone this approach to regulating agriculture statewide. Additionally, on page 58, the board directs the Central Valley Board to convene an expert panel within 18 months after the adoption of this order. It sets no deadline by which the panel must actually make findings. This delay fails to acknowledge the extensive information in the record on surface water monitoring, and it fails to acknowledge the urgency with which the board must address the degradation of California's water.
Thank you, Donna. The doctrine of substantive due process indicates that the government cannot infringe on fundamental liberty interests unless that infringement is narrowly tailored to serve a compelling state interest. Fundamental liberty interests are drawn from the Constitution. Thus, Californians have fundamental liberty interests in life, bodily integrity, and happiness, among others. Given its lack of enforceable standards and anonymous third-party reporting system, the current order does not adequately protect water quality. This damages people's health, livelihoods, and property, and thus violates their liberty interests. The identified deficiencies in the order are in large part justified by saving costs to growers. However, case law indicates that saving costs is not a compelling state interest. California holds navigable waterways in public trust for the benefit of its people. The public trust doctrine creates an affirmative duty for the state board to protect these waterways. The current order does not mention the public trust doctrine. It does not address the public trust values that are being sacrificed. It doesn't identify potential measures to protect those values, and it also does not address the feasibility of those measures. Additionally, the board unlawfully abdicates its public trust duties by using third-party coalitions. The California Constitution creates the reasonable use doctrine, which states that the waste, unreasonable use, or unreasonable method of use of waters must be prevented. The board does not analyze whether the order complies with this doctrine. The order allows for waste by letting farmers over-irrigate their land. The order could specify a water duty or level of reasonable efficiency. Additionally, in determining waste, courts consider alternate uses, and we think that the agricultural use here appears especially wasteful, given that an alternate use is drinking water, and that the Water Code explicitly prioritizes drinking water over agriculture. The order also allows for the unreasonable use of water. It is unreasonable to devote so much water to incredibly water-intensive crops. Additionally, the use is also unreasonable because it causes water quality problems in surface water and groundwater. These water sources are used for drinking water, which is protected as a human right in California. This human right to water was recently recognized by the California legislature in the Water Code and the Health and Safety Code. The legislation specifically protects a right to clean drinking water. As recently as 2016, both the State Board and Central Valley Regional Board identified this right as a core values in resolutions. The current order allows water pollution in the Central Valley by not including enforceable standards for nitrogen or pesticide application, and by using third parties to collect and anonymize data. It thus does not adequately protect the public's right to safe drinking water. The California Constitution, legislation, the non-point source policy, and case law all recognize the public's right to have information about water quality programs. The order violates this right by allowing third parties to collect, retain, and anonymize data. We are additionally concerned about the new language on, quote, private economic information and general concerns regarding privacy, unquote, and its ability to be used to block the public's right to information. Agencies cannot delegate legislative and discretionary powers to private groups and also cannot contract away their right to exercise the police power. The order violates these non-delegation and non-abdication doctrines by its use of third-party coalitions.
Thank you, Sarah. We are concerned that the proposed order and its iterative management practices will fail to ensure compliance with the Central Valley Basin Plan. It lacks meaningful standards for enforcement, and the anonymization and aggregation of grower data will lead to a non-transparent regulatory regime. Additionally, the Basin Plan requires water shall not contain biostimulatory substances which promote aquatic growths in concentrations that cause nuisance or adversely affect beneficial uses. This narrative standard is not addressed in the proposed order. We are further concerned that the 5 elements of the State Board's non-point source policy are not adequately addressed by the proposed order. The anonymization of aggregation of data is a problem here as well, as it will make enforcement exceedingly difficult and ineffective, as it provides no quantifiable timelines with respect to individual growers' compliance with the policy, and limit the ability of regional boards to target remedial action towards specific growers. The proposed order also fails to provide sufficient enforcement mechanisms to comply with the State Board's anti-degradation policy. It does not summarize the impacts of discharge, and it also concedes that practices will, quote, evolve, and so the ones provided in the order cannot meet the requirement that they will ensure the best practicable treatment and control. In addition, it is well-settled law that water pollution is a public nuisance. The proposed order will create a public nuisance because it permits the continuation and exacerbation of water pollution in California waterways. The lack of enforceable limitations on pollution or timelines for monitoring and compliance are violations of the State Board's duty to abate public nuisances, such as water pollution. Latino communities are more likely to have higher nitrate levels in their drinking water than the population at large. These communities of color already face difficult challenges in accessing healthcare, water treatment, and alternative water sources. State anti-discrimination law prohibits the government from denying citizens, quote, the full and equal access to the benefits of, or for citizens to be, quote, unlawfully subjected to discrimination under any state program or activity. Low-income communities, some of which are also Latino communities, face higher rates of nitrate pollution as well. The situation violates state fair housing law, which renders, quote, null and void government action that infringes the rights of low-income Californians to the enjoyment of their residence, land ownership, and tenancy. We're concerned that by failing to redress these race and class-based inequities, the order violates these laws. To conclude, we would like to call attention to how, just this past Friday, on the final page of the redlined version of the order at the time, the State Board indicated that the irrigated lands regulatory programs across the state will continue to, quote, evolve. This exemplifies the overall indeterminacy of the order. Does not set firm standards for nitrate or pesticide pollution, quantifiable timelines for compliance, or other substantive enforcement mechanisms. We are concerned, if I may finish, we are concerned the board is continuing to create unnecessary delay and will not achieve its imperative to address the degradation of California's waters and protect the health of those who rely on it. Thank you very much for this opportunity to comment on the draft.